I was recently involved in a joint action between Treasury and OFAC into the potential failures of an AML program and also lapses in sanctions screening compliance. And it was against a money services business that was registered properly, but had a lack of controls such that they allowed transactions through from sanctioned countries. And when they got notice of an investigation, they wondered, how did this happen? And it became clear that when they were setting up their sanction screening program, they hired a third party who advertised the ability to do it. And either through their own fault by not setting up that screening process properly, or through the fault of the vendor, it's never been clear, they inadvertently allowed screening to only screen off of the named lists. And for several years, transactions were, they thought, being screened for both the named list and the geography, but in fact the geography screening wasn't turned on. As a result of that, many hundreds of accounts were able to be created on their platform from Iran and other sanctioned jurisdictions, and thousands upon thousands of transactions, not all of which were very large. Some of them were even less than a cent. But the number of transactions mounted, and so by the time they were in a position to try to talk to OFAC about the sanctions compliance problem, they were faced with an astoundingly large base penalty. And it's worth mentioning how that happens. If you get stuck in an enforcement action with FinCEN or with OFAC, you will likely start from the position of, well, this is a strict liability regime, which means that if you process transactions from a sanctioned party, you broke the law. There's no wiggle room. It's called strict liability. And that's why we like to call this the snake in the grass. I mean, you think you're doing everything you can on a reasonableness standard by developing a good risk assessment and good AML controls and a good anti-money laundering policy, and you've got transaction monitoring. And if there's a lapse there, the reasonableness of your efforts affords for some wiggle room in terms of compliance. I mean, FinCEN knows that sometimes every financial institution is subject to some kind of misuse. And that's why they have a SAR reporting or a suspicious activity reporting mechanism, because they understand that there will be instances where people try to use the services for bad purposes. OFAC's different. They expect, I mean, the law dictates that they expect zero error compliance with those sanctions. And if you end up in a spot where you violated the sanctions, they have to calculate a base penalty based on a numerical formula that uses two major inputs. One is the volume and value of the transactions, and the second one is the number of transactions. Now that made sense when the lowest you could ever go is a penny. But now, with things like crypto and other kinds of trading, there can be hundreds of thousands, maybe a trillion transactions worth fractions of a cent. And if the calculation simply measures each transaction as a unit in its calculation of a penalty with an assigned dollar value, that can go astronomically high. Such was the case with our client. And the base penalty ended up being so high that it seemed almost crippling to the company. Now, they were able to negotiate that down to a reasonable settlement, and it did end with a happy ending, but not one that was without some pain. I mean, it did end in a settlement, it did end with a monetary penalty, and it did end with a fairly large and painful fine that the client ended up paying. But it wasn't the base penalty, and it wasn't the base penalty because they were able to show some mitigating circumstances. And so one of the things we talk about with new clients when they're doing all of their compliance, they're very fixated on the AML program itself, setting up all the controls for compliance. And that's partly, I think, because it's so detailed and it's so much work that's where they put their focus. In fact, when I first started practicing, most new crypto businesses, for example, would merge their AML compliance program with their OFAC program as one program. And as a result of some of the enforcement actions and interactions we'd had with regulators, it became clear to us that just one thing we could change to make that easier was to simply segregate those programs into two pieces. So we would have one be the AML program with all of its controls, and then we would have an OFAC program with all of its controls. And that sort of made the point to the compliance staff at these companies that they needed to treat them as separate issues. That when you are doing all of your anti-money laundering compliance, you're not really doing screening sanctions.